You are with the big story here. I'm Seher Zama, and this is our top focus. Five-judge Supreme Court bench, which is led by Justice N.V. Ramana, is to examine the curative petitions filed by two Nirbhaya gang rape convicts. This is happening as we speak. The two convicts here being Vinay Sharma and Mukesh. The two convicts have moved the curative plea after the Delhi High Court issued death warrants in their name, announcing 22nd of January as the date of their hanging, their execution. This after the High Court already having dismissed their review pleas just last month. So curative petitions is the last and final legal remedy which is available to a person. It is available to the convicts in this case. Let's in fact get in more voices here on this. We'll get you further updates here from the Supreme Court in just a bit. Let's get in a word here from Mr. B.L. Vora, who's the former DGP, Justice Saldana, former judge of the Bombay High Court, with us. Appreciate you being with us, gentlemen. First to you, Justice Saldana, in what has been followed as per procedure in this case. Today we are looking at yet another option, a legal remedy which is available to the convicts. Of course, there is an argument that this could delay the hanging which is already ascertained to be 22nd of January in a few days' time. What in your view could happen? Does this have the potential to delay a date of hanging that has already been ascertained by court?
Well, if a valid point is made out, the possibility of the Supreme Court looking into it cannot be ruled out. But my view of the matter, and I think that view is unanimous, is that the judiciary also works on the concept of finality. And in the case of heinous offenses, the judges, the High Court, Supreme Court, the judges who hear the matter right from the session judge, they are responsible judicial officers. And the law postulates lots and lots of safety measures. The law postulates, for instance, the concept that capital punishment should be awarded in the rarest of rare cases. And there are so many other principles. Now, these are looked into by the trial court. After that, the case is required to be reconsidered and reviewed by the High Court. Now, the High Court is very, very careful as far as confirmation cases are concerned. The judges are careful. And the possibility, any possibility of an error, to my mind, is virtually ruled out. Now, once you pass that stage, everything else is what you call special remedies. Now, the curative petition, undoubtedly, the law provides for it. And I have no objection, nothing to say about that. My only point is that from the angle even of the accused themselves, there should be a degree of expediency. I'm not saying no, these cases are always taken up on priority basis, but it has got to happen much faster.
Yes.
Because I have seen, when I was a criminal lawyer, I've gone to the jails, I've seen people on death row, and I mean, it is indescribable what kind of condition they are in. And according to me, if they have to be executed, it should be done as soon as possible, but undoubtedly after exhausting all the possible avenues and remedies, including mercy petitions, etc. I'd like to see some more, I'd like to see speed. I'd like to see all this. To my mind, all these procedures can be completed possibly within an outer limit of 2 to 3 months. I mean, even that's being generous.
Okay.
Because the judges don't take time. Ultimately, they assign top priority. So I'd like to see some speed. But in any case, we've got to wait and see what view the judges take. We don't know what point is being raised, whether there's any substance to it. If there's no substance, undoubtedly the petition will have to be dismissed.
That's right. Mr. Yashodhan Azad, former IPS officer with us here as well. Mr. Azad, thank you for being with us. Okay, yes, please complete your point.
All I want to add is that you see, I do not share this kind of bloodlust. Undoubtedly, there are people who are deeply hurt. Undoubtedly, there are people who are very offended, and it's a kind of this kind of retributive attitude is I would say it's quite natural among human beings, but I don't share it. While at the same time, I do maintain, because I've given this matter a lot of thought, and I do maintain that we have a small class of human beings who are given to extreme violence, and this violence now a
Yes.
kind of a gang rape or a rape or terrorism, etc. These are cases of extreme violence, and they are according to me offenses
That's right.
against humanity, offenses against society. And when a person is found guilty to have committed an offense of this type, my confirmed view is that that human being has forfeited the right to live. Now let me just recall one incident in the case of Kasam.
Okay. No,
I mean, this man,
please stay on with
ran
us. I
riot,
apologize for the
and
interruption
he
here,
had,
but I have
he
to
had,
go across to
it
my
cost
colleague
us.
here. We have with
Yes.
us our deputy news editor Meenakshi Bhanja, who's right outside Supreme Court. This is the start of the hearing of the curative petition here. Meenakshi is getting us further inputs in the arguments on what is going to be heard today, and the fear that could this delay the hanging of the date is certain, 22nd of January. Meenakshi, take us through some of those arguments there.
Well said at the outset. What is very pertinent is that this is 5 judges of the Supreme Court that we are speaking about, who are going to be devoting their judicial time. They were slated to meet at 1:45 in chambers. As we have been given to understand, they have indeed met up in chambers, and they will now mull over these points that the curative of 2 of these convicts are raising. One, the argument that they're making is as to how the reformative aspect of justice has been purportedly overlooked, given the fact that they are relatively of young age, and again they are sort of looking to put their foot inside that little window of legal process which has been left ajar for them, and they're seeking for a stay on the death warrant. Now, till and unless the death warrant is specifically stayed by the Supreme Court, it stands as of now as slated for execution on the 22nd of January. But the very fact that you have 5 judges sitting in chambers ahead of 22nd January is a clear indication that the Supreme Court is very cognizant and sensitive to the fact that this is a matter which should be brought to its logical conclusion, and this is happening after 3 tiers of judicial scrutiny has already been applied to this case, from the trial court to the High Court to the Supreme Court. And then subsequently, remember, the review jurisdiction of the Supreme Court was also invoked, in which, as per the 2014 judgment of the Supreme Court, all death row convicts are given an open court hearing, which was the case in this particular instance as well. And our viewers will recall it was only recently on the 18th of December 2019 that the Supreme Court not just conducted an open court hearing for the last convict Akshay, but also dismissed it the very same day. So clearly, we are looking at the fag end of the legal processes as envisaged under the Constitution be completed here.
Right. Okay. Yes, Meenakshi, please stay with us. Keep getting us those inputs coming in from the Supreme Court right now. Going across to our panelists with us, also Mr. Yashovardhan Azad, former IPS officer. Appreciate you being with us, Mr. Azad. In your view, in what is also elaborately explained by Justice Saldana just a short while back here, that this was a process with multiple stages and levels of legal recourse and rights of the convicts available, could have been wrapped up in barely 2 to 3 months after the crime. And it is something that we're looking at still continuing 7 years down the line.
I totally agree with you that this is a very, very long and agonizing process for all the stakeholders. In fact, let me compliment Nirbhaya's mother, who's maintained her grace and dignity, and with what sobriety she spoke to the television channel. I really admire her courage and fortitude. But this is something which we have seen is becoming really painful, that it's a very long process. And I'm glad that a 5-member bench is sitting today to give a closure to this. But I do feel that all such cases should be brought to the book immediately, as soon as possible. And for that, of course, the police systems have to become more efficient. They have to be more capacitated. And also the legal system and the legal course. In fact, the entire till the trial period and the judgment and the sentence should not take more than 1 year. In that respect, I do agree with the Honorable Justice who has spoken before me. But I do feel that there are too many
breaking inputs here coming in. Supreme Court, which has been examining these curative petitions, have now been dismissed. These are breaking inputs coming in, a confirmation here that's coming in from Meenakshi Banja with those details. This has been dismissed. Curative pleas have been dismissed, which was filed by 2 convicts here in this case. It has been rejected. This is a 5-judge Supreme Court bench which was hearing these curative pleas. It's important to note none of those arguments that have been put forth by lawyers of the convicts has been taken into account. This is a curative plea which has been dismissed. Meenakshi getting us those details as we speak. Remember, it's important also to note this was the last and final legal right available to the convicts. Yes, they still have an option of putting in a mercy petition directly to the President of India. Whether or not they would go ahead and do that, remember, there is time till the 22nd of January to do that. But important to note, curative pleas of the 2 convicts has now been dismissed, and this has been dismissed by a very strong 5-judge bench of the Supreme Court. Meenakshi getting us further inputs here on what has been spoken by the Supreme Court with this rejection.
News at the outset, we're breaking it first on Midden now. The curative petitions which were being considered by 5-judge bench composition of the Supreme Court in chambers did not see the presence of any lawyers or arguments as these proceedings were conducted in chambers. But the breaking news coming in is after a 15-minute consideration, the news breaking is the curative of 2 of the convicts, Vinay and Mukesh, stands dismissed by the Supreme Court of India. So all those arguments that they had forwarded pertaining to youth being a factor, reformative part of justice being a factor, clearly not finding any resonance with the 5 judges of the Supreme Court, not wasting time. 15 minutes in chamber consideration. The news breaking this moment is how the Supreme Court has not hesitated and gone ahead and dismissed this review. There have been certain pertinent points to the hearing itself. Remember, this is an in-chamber curative which is happening ahead of the 22nd January execution date that has been set in place by the magistrate. A clear indication had come by now when the date of 14th January was allocated by the Supreme Court for the in-chamber hearing. And as we speak, this curative stands dismissed. That means 2 of those convicts have exhausted all of their legal recourses. The only option now is the mercy petition before the Honorable President of India. And the President is also very cognizant and sensitive about the enormity of the message that this case has. And he will be guided by the aid and advice of the MHA and also the Council of Ministers. So, yes, what we are seeing play out is the matter progressing towards the logical conclusion. Remember, the death warrant has not been stayed by the Supreme Court of India. Till and unless a death warrant is stayed, it means that it is up for execution and operation on the 22nd of January. The big breaking news coming in from the top court. 5 judges met in chambers without lawyers, without arguments. They went through the paperwork, they went through the filings, they saw the arguments that have been advanced earlier occasions today as well. They have brushed aside these law points that was looking to perhaps buy some time, and clearly unimpressed after 15 minutes consideration, these 5 judges have gone ahead and dismissed the curative. Now, curative, as the name suggests here, means to cure irremediable harm that may have been committed by way of the earlier judgments of the Supreme Court. Clearly, this, according to the judges of the Supreme Court, the 5 notable judges of the Supreme Court led by Honorable Justice Ramana, is not a case which is fit for a curative, despite, remember, finding a senior advocate called
Right.
Adish Agarwal, who signed the curative in the backdrop of several eminent seniors who were not putting their signature to the curative. This curative got filed only to be dismissed
Yes.
after a 15 minutes worth consideration, because according to the Supreme Court of India, this is not a case which is an irremediable wrong which needs to be cured.
Right. And giving barely 15 minutes to take that decision, Meenakshi, that is, of course, an important insight that you brought us. Let's also get in a word here from Ms. Shamina Shafiq with us. She was a former member of the NCW at a time when this horrifying gang rape had taken place. Shamina, thanks for being with us. Your first reaction to this decision, the Supreme Court making it very clear, barely giving 15 minutes time to that 5-judge bench, making it clear that this is not a case which needs to be revisited. The curative petition has been junked, has in fact been shot down by the Supreme Court.
Well, very honestly, very grateful to the Honorable Supreme Court of India, grateful to the Indian justice system that finally, one more hurdle has been crossed. Trust me, these are hurdles which all the women, not just women, I think in the entire nation is very keenly watching up to, because 22nd is the day then when finally, these criminals are going to be punished properly and some justice. Why I say some justice? Because proper justice can never be given to the parents of Nirbhaya, because Nirbhaya is no more with us. But the kind of harm that these criminals, these brutal criminals did, not just to Nirbhaya, to her family, but also to the reputation of the Indian police system, to the reputation of Indian judiciary system, to the reputation of entire India as far as women's safety is concerned, that is also irreversible. I mean, the way the entire world was shocked and was actually very, very angry as far as this case is concerned. Yes, I was a member at the National Commission for Women in 2012 when this unfortunate case happened. So the kind of anger was there in the world. The entire world is looking at India as to what kind of justice does Nirbhaya and other hundreds and thousands of Nirbhayas get in this country. So 22nd is one day which we are eagerly waiting for, and I hope that the next hurdle also, we cross without any delay, and these people are hanged till death, because nothing, for that matter, even their death cannot bring back Nirbhaya, but some sigh of relief, some hope in the justice system is going to get back to the Indian ethos, especially the women who have lost hope, and not just women, as I said, the entire country. And this is why what we saw in Hyderabad after the Hyderabad encounter, that there was a kind of happiness within the people that, oh, that this is justice. That was not at all good, because in a way it was signaling that people had lost faith in the Indian judicial system, which is not good for any country. So
and the delays that have been seen. That's right. Shamina, stay on with us. Yes, please stay with us. Also getting in Ms. Mamta Sharma, who was in fact your colleague at the time, the NCW chief at the time of the Nirbhaya crime here. Ms. Mamta Sharma, appreciate you being with us. Your first reaction, keeping in mind that the Supreme Court barely gave 15 minutes to this, making it very clear, curative plea in this needs to be shot down. It is an available legal right of the convicts here, but this is one of the most horrifying crimes, rarest of rare. Curative pleas have been dismissed, rejected by the Supreme Court today.
फाइन तो था ही, साथ में बहुत हीनियस क्राइम था जो ये हुआ दामिनी के साथ, और मैं सोचती हूँ कि 7 साल इनको जिंदा रखना भी एक बहुत बड़ी बात थी. इनको बहुत पहले ही डेथ सेंटेंस देना चाहिए था. लेकिन मेरा मानना ये है कि ये जो क्यूरेटिव पिटीशन को जजेस ने डिसमिस किया है, बहुत अच्छा फैसला है, और ये लास्ट होप जो इनकी थी वो भी खत्म हो गई, जिसपे ये जिंदा रहना चाहते थे. मैं समझती हूँ ये एक एग्जाम्पल सेट होगा और दूसरे जो क्रिमिनल्स हैं उनके लिए भी, और जो इस तरह के क्राइम करते हैं उनके लिए भी. जैसे हैदराबाद वाला एक जो वो था, वो बहुत बढ़िया एग्जाम्पल सेट हुआ. हालांकि पुलिस को सबने कहा, लेकिन पुलिस जब खुद मरने पे आ गई तो पुलिस क्या करती? उन्होंने उन लोगों को मारा, तो मेरा मानना ये है कि इस तरह के क्राइम को
Okay, we're getting in more reactions here. This is from right outside Supreme Court. Let's take a listen into those voices.
मिलेगी, उसके बाद जो भी हमारा क्लाइंट कहेगा, जो भी क्लाइंट से हम बात करेंगे, उसके बाद जो भी आगे की लीगल रेमेडीज हैं, फर्दर रेमेडीज हैं, वो हम उसको पूरा करेंगे।
लीगल रेमेडीज करेंगे, क्यूरेटिव तो हो गया, क्या मर्सी पिटीशन अब बचता है?
हाँ, जो आप बताएंगे, जैसे आपने मर्सी पिटीशन बताया तो मर्सी पिटीशन बताएंगे, यही मीडिया तो बता रही है। मैं यही तो कह रहा हूँ, ट्रायल है ये, मीडिया के क्वेश्चन से ही जवाब निकलते हैं। मीडिया ने कभी ये नहीं पूछा अगर आपके क्लाइंट की फांसी की सजा कम हो जाएगी, उम्र कैद में बदल जाएगी, तो आप क्या करेंगे। अगर ये पूछते तो मैं उन्हें अच्छा जवाब देता कि अगर इनकी फांसी की सजा कम हो जाएगी तो उन्हें पाकिस्तान की सीमा पर शहीद होने के लिए लगा देना और भारत की आन मान शान की रक्षा कर लेना। ना ये करना, ये पूछेंगे नहीं।
मेरा ये कहना है कि आपकी मीडिया से जो भी आपको मनमुटाव है वो अलग।
ना मीडिया तो मेरे भाई है, मीडिया हमें रास्ता बताते हैं।
ऑप्शंस क्या है?
अभी हमारे पास लीगल रेमेडीज, हम क्लाइंट से बात करेंगे, हमें जजमेंट मिलने दिया जाए, जजमेंट देंगे और उसके बाद हम उसमें देखेंगे। क्योंकि हमने अभी भी विनय शर्मा के अभी हमने विनय शर्मा के जो जिसकी डिसमिस हुई है क्यूरेटिव पिटीशन, हमने उसके लिए जेल से डॉक्यूमेंट मांगे हैं। हमने 8 तारीख को भी जेल में यहाँ पटियाला हाउस कोर्ट में एप्लीकेशन देके कोर्ट मांगे। मैं 10 तारीख को तिहाड़ जेल की दोनों जेलों में मिला, वहां हमने डॉक्यूमेंट मांगे, अभी नहीं दिया। और 13 तारीख को पटियाला हाउस की स्पेशल कोर्ट में हमने एप्लीकेशन लगा के विनय शर्मा, पवन कुमार और अक्षय के डॉक्यूमेंट मांगे हैं। जो डॉक्यूमेंट हमें
है आपके पास, क्योंकि ऑर्डर डेथ वारंट तो अभी भी साइन हो चुका है।
हाँ, नहीं, डेथ वारंट तो साइन करना उनका काम है, अर्जी लगाना हमारा काम है, डिसमिस करना उनका काम है। मर्जी उनकी, अर्जी हमारी, मर्जी उनकी। और ये है क्योंकि
पिटीशन के लिए कब जाएंगे, कितने दिनों?
मर्सी पिटीशन के लिए हम सारी ग्राउंड लेके जाएंगे। कोई इन्वेस्टिगेशन जिस तरह से आइडेंटिटी है, क्योंकि इस तरह से आपने देखा डीएसपी देवेंद्र जैसे लोग आतंकवादियों के साथ
अभी की बात कीजिए।
अरे 1 मिनट है ना, मैं आ ही नहीं रही हूँ, आप
This is the legal counsel of the convicts, Vinay Sharma, saying that we will once again now scrutinize the judgment of the Supreme Court and having shot down the curative pleas, legal remedy available, which is of course mercy petition, which is going to be put in as mercy petition to the President of India. Going across to Justice Saldana here with us. Justice Saldana, in various voices who are speaking out in pain, in having seen the pain and delay in this case, are looking at these as hurdles. These are legal remedies available to the convicts of this horrifying, gruesome crime that perhaps the entire world has never seen, and they're looking at these legal remedy available as hurdles to the delay in justice. What would you have to say on that?
Well, let me prefix my answer. There was some emphasis on the fact that the Supreme Court took only 15 minutes in order to indicate its decision. Now, I want to clarify that I have been a judge for 16 years, and here we have 5 of the country's senior most and 5 of the country's finest legal minds. And when a petition of this type is filed, the judges go through it threadbare. They consider it, reconsider it, they go through it threadbare, and all of this process takes place outside the courtroom. This is the homework that a judge does. After that, when they meet, they deliberate, and it's not just 1 or 2, there's 5 of our finest legal minds. And when they put their heads together and they arrive at a unanimous decision, I don't think one has to look at the time factor. One has got to consider that this is probably the 100% correct, expeditious decision that was expected. Now, as far as this delay aspect is concerned, again let me point out that the point that was argued, namely whether these people, considering their ages, whether that should be a consideration. Now, I want to tell you that if you look at the different considerations that have been gone into by the different courts at different times, this is one of the first things that a court considers. The second aspect of the matter is, now, the argument is that can they be reformed? There is a class of human beings, research has shown, a class of human beings who cannot be reformed. They are incorrigible. They are beyond redemption. Now, you cannot go on arguing ad nauseum that you give them one more chance, etc. I started by saying that we've got to apply the concept of finality,
Justice
and
Saldana,
that
your
has been done by the Supreme Court.
That this is a class of human beings that cannot be reformed. They have acted like animals, they cannot be reformed, and yet they still have access to that legal remedy as per law. They still have access to a review petition. They still have access to a curative petition today. They still have access to a mercy petition in the future.
See, this is one of the reasons for all of this is because if an execution takes place, then assuming there is even a 0.1% error, it can't be corrected. And the only example I'd like to give you is that in one of the IRA trials in the UK, after 9 years, the court reviewed the whole case and they acquitted the man. And one of the observations made was that thank God he was not executed. And after that, the death penalty was scrapped in the UK, because they felt that even if there's the slightest margin of error, it can't be undone. But I don't really share that view, because with the amount of scrutiny, with the amount of competence that the different judges and others involved with the case has put in, the chance of error, according to me, is absolutely zero. And if that is the case, I mean, undoubtedly the President will consider, if they file a mercy petition, the President will consider it. He'll consider it on merits. I don't want to say anything about that. But as I started by saying that even if you have 10 procedures, for God's sake, please expedite them and finish it fast. That's my only plea. And that's my plea.
Yes, Nirbhaya's mother speaking to the press here. Let's in fact take a listen in. She's taking up the victory sign, about to speak in a bit.
आशा देवी, अरे यार आशा देवी कितना बड़ा दिन है आज आपका क्यूरेटिव?
आज मेरे लिए बहुत बड़ा दिन है, क्योंकि हमने 7 साल से मैं संघर्ष कर रही हूँ, आज के डेट तक कर रही हूँ, तो ये मेरे लिए बहुत बड़ा दिन है। लेकिन सबसे बड़ा दिन 22 तारीख को होगा, जब वो चारों फांसी पे लटकेंगे, और उम्मीद करते हैं कि जो भी आगे उनकी रेमेडी है ऐसे ही खारिज होगी और उनको 22 तारीख को फांसी होगी।
आप कह रहे हैं ये लोग फिर से लीगल रेमेडी के लिए जाएंगे। पी सिंह जो कह रहे हैं कि मीडिया के दबाव में इस तरीके से हो रहा है, आपका क्या कहना है?
वो उनका जो भी काम है कहना कहें, लेकिन ये मैंने 7 साल कानूनी के तरह से, कानून के हिसाब से लड़ा है, कानून के तरह से ही हमें इंसाफ मिलेगा और उनको फांसी होगी।
एक बहुत बड़ा दिन कहेंगे।
आप आओ।
एक और
आशा जी, आंटी एक सेकंड, इनको ये नहीं जी।
आशा जी, एक और बड़ा जो दिन, एक और रास्ता हुआ आपकी बेटी।
डेफिनेटली देखिए, हमें बहुत खुशी हो रही है कि यहाँ पर भी सुप्रीम कोर्ट ने जो उनका डिले टैक्टिक जो यूज कर रहे थे, वो डिले टैक्टिक पर बैन लगा, एक तरीके से फेल होते जा रहे हैं वन बाय वन। ये बहुत जरूरी था और हम उम्मीद करते हैं कि 22 को ही इनको हैंग किया जाएगा, फांसी होगी और हमारी बहन को न्याय मिलेगा, जिसके लिए पूरा देश इंतजार कर रहा है। जी, थैंक यू।
Okay, getting in our panelists here on this for a reaction to what Nirbhaya's mother has also stated here on this, in continuing to emphasize this has been a 7-year-long wait. Mr. Azad, in your view, when we talk about, because Nirbhaya's family and legal team have time and again said that they have indulged in delay tactics with respect to legal remedies that are available to the convicts as per our extremely evolved justice system here. They have used this as delay tactics. What kind of legal and judicial reforms would you think that need to be revisited, scrutinized, keeping in mind just this one case as a case study, that the delay is extremely painful?
I have already stated last time that this is a very, very agonizing process, and there has to be systems put in place that this period is shortened. In fact, I congratulate Nirbhaya's mother that she's sans bitterness when she's talking about the sentence, and she's positive and she's looking forward to that day on 22nd when she'll get full justice. But let me tell you that the criminal justice system in such, this case was of extreme brutality, absolutely barbaric. So it's a watertight case, and we needn't have gone through these 7 years. The first thing is that the police systems have to be reoriented, that in all the rape cases, they have to speed up the process. The prosecution has to be of top quality.
Right.
Today, the prosecution
but Mr.
leaves
Azad,
much
in this
to be
case,
desired.
the police filed the charge sheet barely 2 weeks after the crime.
Yes, this was one of the best cases. And in fact, I'm talking about the future when there are not many cases. Imagine that this case had the spotlight of the entire nation and the entire world. And we also had one of the very good commissioners, Neeraj Kumar, at that time, who was piloting the investigation himself. So this has borne fruit, and the police put the charge sheet in the shortest time. But this is not in majority of the cases which are being investigated in the country. And therefore, in those cases, we have to bring about a system in place where there is efficient, effective investigation, and which is put to the court as a watertight case. And also, the prosecution leaves much to be desired. The police prosecutors do not have that capacity to contest the defendant lawyers, who are of a much better quality. And in fact, if you see the lawyers, they are using every ruse, every tactic to delay the case. And that is why all such cases go on for an inevitably very, very, very long time. And that is what we have to reduce.
Okay, that's well pointed out. A public prosecution and the kind of lawyers available in the system, that also needs to be watertight, as must be seen in the defendant's case here. But Shamina, I'm asking you this because you had called this a hurdle. These have been hurdles. Whatever legal remedies have been available to the convicts, they've used it as delayed tactics and hurdles. Because time and again, and what Nirbhaya's mother had also stated, that each time the court asks us to understand the legal rights of the convicts available, no one's thinking about the victim, no one's thinking about the victim's family. How can this case bring about revisiting the legal and judicial system here, which is more sympathetic, empathetic to the victim here?
I'm glad you have asked this question, sir. And I'm sure you have interacted with Nirbhaya's mother 100 times during these 7 years. You talked to her, a lady who was probably confined to her house, to her children, to her family. Within a span of 7 years, know much more than some lawyers in this country as far as laws regarding rapes are concerned. I mean, she's been through this process of legality so much that you talk to her, and I personally feel so proud about the fact that she has educated herself so much. But look at the plight behind this education that has actually come to her as far as legal rights are concerned. Why a woman, or for that matter, why any family has to go through that? So it's high time now, after Nirbhaya's case, it's time to revisit, and there are two aspects of it. Just now, yes, we are grateful that in this particular case, the charge sheet was filed in a very short span of time. We are really grateful for that. But after the filing of the charge sheet, until the judgment was pronounced, which is a couple of days ago, the final judgment, look at the time span, look at the loopholes, look at how the lawyers of the criminals have actually tried to buy time. These things, when media channels can discuss and debate, when the mother of Nirbhaya, who is not a lawyer, knows, then I'm sure that the highest judicial body of this country is very well aware as to where to pull the strings. Now, the gap between the filing of the charge sheet and the justice that is now going to be given, that gap can certainly be time bound. I mean, what is the meaning of taking care of the rarest of the rare cases if rarest of the rare case also takes 7 years or rather more than 7 years to come to a logical conclusion? That is the point that needs to be taken care of. And the second part of this entire discussion debate is how many girls and women in this country, when they file, first of all, filing an FIR after getting raped is a big hurdle. Trust me, it's a big hurdle. Then after filing of the FIR, the amount of pressure that is generally there on the families to take back the cases. And then till the charge sheet is filed, look at the way the investigations are done. So that is also, I mean, we are lucky that in this case, the investigations were absolutely prim and proper, and probably that is why, despite of all the time factor, finally, we are hopeful that the justice is going to be delivered. But maximum of the cases, I mean, after 22nd, I would plea to Mirror now, I will plead to all of you that please try to revisit the cases which are already lying pending in the court as after the filing of the charge sheet. You'll realize the gravity of the situation. And this is high time now. I think all the bodies who are responsible to ensure that women's rights are protected in this country should come down, sit down together and find a proper solution so that no other Nirbhaya in this country has to go through what Nirbhaya had to go through, and no other Nirbhaya's parents should suffer the way, I mean, Nirbhaya's parents have suffered. And there are some parents who are suffering more than Nirbhaya's parents.
Justice Saldana, as per what the law says, and please correct me if I'm wrong here, that the option to file a review petition is within 30 days. But there was a continuous delay to this, where the lawyer of one of the convicts also said that he had a personal tragedy, his mother had passed away. Can any of this be entertained if this is laid down in law that there is? It's not as if our justice system doesn't have a timeline to go by, doesn't have the wherewithals of this being time bound. If there is an option that needs to be followed, not an option, if it is as per law that you can file a review in only within 30 days time, how did this delay happen? How was this entertained then?
Well, let's be a bit human. Small allowances are always made, can be made, but that is no ground. That is no ground for granting adjournments of weeks and months. This is one. That's no ground also for condonation of delay indiscriminately, etc. There is a method of dealing with this. Now let me just make a suggestion, which at the time when the family courts were set up in this country, I had given reasons, and I had supported my recommendation to the government, wherein I said that the family courts should be presided over by women judges. And there are very valid reasons for it. Now, I'd like to repeat that, because I'd like to point out I have no gender biases of any type. But the point is that I would like to recommend that there should be designated courts to try this class of cases. They've got to be designated courts. Don't just send them to any sessions court. Point number 2, let these courts be presided over by not only women, but by hand-picked judges, people of experience, people who are mature, people who are sound in law. And above all, there is such a thing as a judicial temperament which does not stand for nonsense. Let there be a no-nonsense approach. More importantly, third suggestion is that you got to pick special prosecutors. I can tell you as far as I'm concerned, my own case, I have appeared in numerous matters, both for the defense and for the prosecution. I have assisted the state in important matters.
Justice Saldana, I apologize for the interruption here. Meenakshi Bhanja outside the Supreme Court lawns with a voice of the lawyer. Meenakshi, yes, please go ahead.
लेकिन कोर्ट ने भी उस दिन साफ तौर पे बोल दिया था।
ऑडियो ही नहीं आ रहा।
Meenakshi, please go ahead. If my voice is going through, get us the voice here from Nirbhaya's lawyer right outside Supreme Court. Meenakshi, if my voice is going through, please go ahead. Get us her first reaction on this.
Yes, sir. We're coming. Sir, we're being joined here by Seema Pahwa. As you can see, Asha Devi is also right here. She's going to be talking to us very soon. But quickly going across to Seema Kushwaha, counsel for Nirbhaya's parents. As a matter of fact, now I'm being joined by Asha Devi herself. Ma'am, हमें बताइए आज आपकी क्या प्रतिक्रिया है, क्या महसूस कर रहे हैं इस वक्त आप?
देखिए, हम इंसाफ के एक कदम और आगे बढ़ गए। आज उनकी सुप्रीम कोर्ट में जो क्यूरी पटिशन थी खारिज हो गई, तो वैसे उनके पास अब कोई रेमेडी नहीं बची है, क्योंकि उनको कोर्ट ने बहुत टाइम दिया है, जेल ने 2-2 बार नोटिस किया है, इन्होंने इस्तेमाल नहीं किया। फाइनली जब इनका डेथ वारंट जारी हो गया तो इसको लंबा करने के लिए इन सुप्रीम कोर्ट में
15 मिनट इन चेंबर सुनवाई किया 5 जजेस ने, और बिल्कुल उन्होंने कोई मतलब हेजिटेशन नहीं किया और जल्द से जल्द उन्होंने फैसला सुना दिया है,
क्योंकि सुप्रीम कोर्ट में ये तीसरी बार आए हैं
जी।
जब सुप्रीम कोर्ट में इनके अपील पे सुनवाई चल रही थी, 10 महीने सुनवाई चली है, हफ्ते में 2 दिन 3 दिन सुनवाई चली है, तो कोर्ट सुप्रीम कोर्ट के सामने या हाई कोर्ट के सामने पूरी केस ये शीशे की तरह साफ है
जी।
तो मुझे उम्मीद था कि जो भी इनकी पटिशन है खारिज होगी।
आज क्या महसूस कर रही हैं आप?
देखिए, अभी भी संघर्ष बाकी है। आप ही कह रहे हैं कि नहीं वो राष्ट्रपति के पास जाएंगे, तो मैं 22 तारीख तक जब तक ये नहीं लटकेंगे तब तक मैं संघर्ष करूंगी।
So that was Mrs. Asha Devi herself, Nirbhaya's mother, and I'm being also joined by Seema Kushwaha. She's been a counsel for the family in various stages, Patiala House, High Court, Supreme Court. Seema, you know, before the curative bench assembled, we were talking about how this case is clear and the judges sitting in itself is an indication they want to, you know, hurry through the process.
डेफिनेटली मैम, देखिए सभी जान रहे थे कि उनके पास कोई भी मेरिट नहीं था। रिव्यू में जो इनको उन्हीं सारे ग्राउंड पर सुना गया जो इन्होंने ये ग्राउंड इस क्यूरेटिव पिटीशन में उठाए थे, तो डेफिनेटली सभी को एक पता तो चल ही जाता है कि कुछ नहीं होना है, लेकिन हमारे जुडिशियल सिस्टम को समझना पड़ेगा कि वो इतना लिबरल है कन्विक्टेड के प्रति कि अगर किसी को डेथ सेंटेंस दिया गया है तो वो लास्ट टाइम तक अगर मेरे पास आएंगे और कहीं से भी अगर उनको रिलीफ मिल सकता है तो हम देंगे। तो इस ग्राउंड पर इस कोर्ट ने उनको सुनाया, माननीय सर्वोच्च न्यायालय ने, और कोई ग्राउंड नहीं था इसलिए उनका रिव्यू डिसमिस किया गया। जी,
हम देख रहे हैं आपने आशा देवी का हाथ पकड़ा हुआ है, आप क्या कहना चाहेंगी आशा देवी के बारे? आप काउंसिल रही हैं, तमाम उनके उतार चढ़ाव आपने देखा है, यू नो इमोशनल जो बैटल ये फाइट कर रही हैं वो भी देखा है, और ऐसे हाथ पकड़ के आप लोग सुप्रीम कोर्ट में आज खड़े हैं, क्या कहना चाहेंगी इस माँ के बारे? आप
देखिए, इस माँ के बारे में तो मैं यही कहूँगी कि मेरी भी माँ है जो गांव में बैठी है। अगर सीमा के साथ कुछ होता तो उनका भी साथ देने के लिए कोई बेटी खड़ी होती, तो मेरी एज ए इंडियन सिटीजन मेरी ये ड्यूटी थी कि निर्भया अगर इस दुनिया में नहीं है तो हमारे देश में करोड़ों की संख्या में बेटियां हैं, लॉयर हैं लाखों की संख्या में, तो क्या एक बेटी सीमा उनके साथ मतलब प्रोफेशनली के साथ साथ इमोशनली क्या उनके साथ खड़ी नहीं हो सकती है? तो हमारा एक रिलेशन प्रोफेशन से बड़ा है, तो वो डेफिनेटली होना ही चाहिए। देखिए, समझना हमें ये पड़ेगा कि हम जो भी लोग इंडिया में काम करें, मैं नहीं कहती हूँ कि मैं बहुत समझदार हूँ और मैं जो बोल रही हूँ वो 100% लोग उसे पसंद करेंगे, लेकिन मैं इतना कहना चाहूँगी कि जो भी हमारा प्रोफेशन है उसमें हम प्रैक्टिकली वर्क करते हैं, लेकिन जो हमारे देश का जो मेन जो यहाँ का गांधी जी का एक स्टेटमेंट था, वसुधैव कुटुंबकम, जब हम इस स्टेटमेंट को मन से बोलते हैं, पब्लिक के बीच में बोलते हैं, तो क्यों नहीं हम इसको फॉलो करते हैं? मैं तो कहती हूँ कि निर्भया के बाद भी अगर कोई और भी जो बेटियां हैं बहुत सारी, मैं अगर कैपेबल हूँ तो मैं कोशिश करूँगी कि उनको भी न्याय दिलाएं। तो मेरी यही उम्मीद है कि और भी जो हमारी लॉयर बहनें हैं वो सुन रही हैं कि एटलीस्ट वो तो फ्रंट पर आकर के लड़ेंगी उनका केस।
So, sir, I would like to show you the holding of the hands that is happening. This is Nirbhaya Nirbhaya's mother and counsel, Seema Kushwaha. We were just having this brief conversation with her, and even Seema here is visibly teary-eyed, very emotional moment. And the mother there, you can see she still is hopeful that the execution will happen, but she's prepared for the long haul. She's saying that till these convicts meet their fate, which has been now vetted and approved by various tiers of judicial scrutiny, she is willing to fight on. But there you have it, a very emotional exchange and scene. That is Seema Kushwaha saying that she wants to be there for Asha Devi, not just as a lawyer, but also in all emotional capacity, holding hands in the Supreme Court. And clearly a very surcharged, emotional moment for both of them.
Right. Absolutely, Meenakshi. You've got us some very important reactions and have got a very beautiful moment for us here to also experience while watching. Understandably, this is a huge relief. Each time, each step, we have heard their reactions and they continue to stand by with available legal remedies for the convicts here, stand by with patience. Mr. Azad, if you heard that interaction here and if you heard Nirbhaya's mother's remark here when she says, Sangharsh baki hai. Despite that confirmation that is coming from the lower court here, that 22nd of January is the date of hanging, she is well aware of curative petitions of 2 other convicts and the mercy petition available to all 4 convicts. She's ready for the long haul, even after 7 long years. And when she says "Abhi bhi sangharsh baki hai," do you think it is for all of us to be ashamed of that she's someone who's still standing strong and ready for the long haul, expecting that there could still be some changes to the 22nd of January?
You know, you're absolutely right. This is indeed a moment where we really need to think and deliberate. And let me also say with all the humility at my command that our judicial process is a bit too liberal. It's a bit too evolved for a case like this or the criminals where there is a complete watertight case. You know, the lawyers, the defense lawyers get away with adjournments, and then the court sort of gives such long dates that it becomes totally agonizing. Even now, there is a mercy, the last mercy petition left for the president and for the 2 other convicts. But this entire process of these 7 years have not only been painful, we should be ashamed that this is not the kind of justice we really seek, especially for such cases where they are so barbaric. These are crimes against humanity, as Justice Saldana himself said. And I think it's about time that, as per the Supreme Court directions which it gave after this case, and also so many other judgments, that we need to make it a little more sensitive. Even now there are reports that some of the victims are moving around in hospitals and there is no sensitivity at all in dealing with their cases, with the doctors, the way they are treating them. And in this respect, what Shamina Shafiq said, I totally agree with her, that there should be a lot more sensitivity. I also agree with Justice Saldana when he says there should be women sessions judges. But you know, this problem becomes administrative in the various states to get them at a particular time. So if the systems are set, then we'll have a good system. And who's going to set the system proper? All of us are stakeholders, and we have to work towards it.
Right. Shamina, I'll allow you to respond to that here. Also a reaction, if you may, with respect to what Nirbhaya's mother and Legal Voice has spoken here on this, that they're still prepared, that this is perhaps not the final step. They're still prepared, waiting right up to, holding their breath up to the 22nd of January. Do you think this is something that we need to be saddened about to an extent? Because they perhaps still think that they need to be prepared if at all there could be changes to this, even at this later stage?
I'll tell you, Seher, I mean, first of all, The irony of the entire scenario, what Nirbhaya's mother spoke just now, the irony is that unfortunately, I hate to say this, I'm an Indian, but unfortunately we Indians have sort of lost faith in the Indian judiciary system. And that is the irony, and probably that is why this mother who has lost her daughter, who's been fighting on the roads for 7 long years, not just for her daughter alone, but also for so many other daughters. I mean, she's prepared for anything, for the inevitable. Maybe something happens, you never know, because this is how it has been. So these things have to be really looked into, and a big actually applaud to Seema. Seema is a young lawyer, but the way she has stood by Nirbhaya's mother is something which actually commands huge applaud at the same time. But we also need to realize that,
yes.
I mean, I hate to use this word, but still Nirbhaya's mother has been lucky that the entire Indian media is sort of supporting her in her fight, in her cause. How many other, or rather, there are hundreds and thousands of Nirbhaya's mothers in this country who don't get this kind of limelight. I mean, somewhere down in Northeast, somewhere in the South, somewhere in Bihar, somewhere in UP, I mean, distant districts, there are girls, there are women who are fighting every day. So what
Shamina,
are we going
you're
to
saying
do
this,
about
of
them?
course,
After
understandably
20
from
seconds,
experience
I mean,
in having
sometimes there's a mixed
interacted with
reaction.
several of the rape survivors. Yes, in understanding how difficult the system is, and this is perhaps the case that needs to be studied if at all we decide to revisit the system of judicial reforms, legal reforms, judicial legal remedies that are available to the convict here. Does that need to be revisited, especially when a crime such as this has already been established as the rarest of rare? So why the delay? We appreciate all our panelists here being with us, getting us those first reactions from on ground, from our team here as well. We'll have to leave it at that. But remember, as we mark this day in the Supreme Court shooting down the curative petitions in barely 15 minutes, remember, only 2 of the convicts have put in a curative. The other 2 convicts here could still put in a curative, and all 4 could still put in a mercy petition. This despite the fact date of hanging having a certain 22nd of January. Thanks for being with us.